Everybody, my name is TJ Scott, and I'm an estate planning attorney with the Law Office of Timothy J. Scott. I can be found online at tjslawoffice.com. And today I want to tell you a little bit about a particular tool in an estate planner's toolkit. And that tool is called a transfer on death deed. A transfer on death deed, when it's executed and recorded with the county, by operation of law, transfers the house at your death to the beneficiary that you've listed on that transfer on death deed. A good way to think of it is it's like putting a beneficiary designation on your home. And like a beneficiary designation, it's a future gift that's going to happen by operation of law after you pass away. And it also means that you maintain complete control over the home while you're alive, which is fantastic. You can change that transfer on death deed. It's also sometimes called a TODD at any time, including by selling the house or just by recording a new transfer on death deed on the home. And you don't need approval from the beneficiaries that you've listed on the transfer on death deed, which is something that you would need if you had instead gifted the house outright to the kids or created what's called a life estate in the house. Now, I've talked about probate in the past, and because a TODD functions like a beneficiary designation, a TODD is fantastic for avoiding the probate process. And probate, as you remember, is that burdensome court procedure that has expenses attached to it and takes a really long time. It's also a way for your creditors to come forward and get paid. But a transfer on death deed not only avoids that probate process, it also avoids some creditors that you have at your death by immediately transferring that house out to your beneficiaries. Having said that, it sounds fantastic, and it really is. It's a great tool for certain situations, but I have 4 cautions that I want to offer you today. And the first caution is, how many beneficiaries are you leaving the house to? So the beneficiaries that you have, let's say that it's going to 2 kids, for example. Well, when the 2 kids receive the house as beneficiaries, they need to get together and agree on what's going to happen with the house together. And if there's a disagreement, if one thinks we should keep the house and rent it out and the other thinks we should sell the house, then unfortunately there becomes a deadlock, and it becomes really difficult to move forward and have anything happen with the house. And I've seen that happen before, where there's these deadlocks. In fact, I saw such a bad situation one time that it meant the house was sitting vacant 10 years later and had basically reduced in value to almost nothing because windows had been broken, the elements had been let in, and there just wasn't an agreement about what should happen to the house, and unfortunately fell into disuse and disrepair. Another issue with your beneficiaries is not only do those 2 kids get to be a part of the conversation, but their spouses get to be a part of the conversation as well. Here in Minnesota, spouses have an interest in the real estate that our spouse owns, and it's also true with property received through a transfer on death deed. So not just do you have the 2 kids, but you also have their 2 spouses, so 4 people now involved. And you can imagine if you're trying to leave the house to 3, 4, or more people, how many people get involved and how difficult it can be to arrive at agreement between all of those people. Another part of listing beneficiaries that you have to be aware of is it can be difficult to name contingent beneficiaries in the event that a primary beneficiary does not survive you. In fact, it can be very difficult and very picky about how you word those things, if it will even take effect at all, those contingent beneficiaries. So it's not ideal if you're worried about your primary beneficiary not surviving you, or if there are multiple primary beneficiaries. That was all number 1. Number 2, if is that the beneficiary is going to take title to the house as it is at your death. And so you need to think about, is your beneficiary right now, or will they be at your death in a place where they can pay the expenses and prepare for a sale or to keep the house? you can imagine the expenses that you have running on the house, a mortgage, utilities, taxes. Is there a way that you can provide a source of assets for that beneficiary in order to continue making payments on the house? Because once you're gone, that house transfers to your beneficiary and it's now in their name, and they need to take on responsibility for the expenses and for the upkeep of that house in order to keep it and maintain it in a sellable or a rentable condition where they can actually use it. If they don't maintain it in that condition, then unfortunately it can become a burden to them, can even become a liability to them in having to deal with it. Number 3, it is very important to execute the transfer on death deed correctly, and there are a lot of ways that you can go wrong here. Number 1, you want to make sure that you have the correct names of grantors on the transfer on death deed, and the best thing to do is to look back on the previous deed and pull forward the names of what was the grantees and is now the grantors, the person who is giving this interest in the real estate at this point. You want to make sure that those match as closely as possible, because if they don't, it could cause the county to reject it when it goes for filing. You also need to make sure that you get the exact correct legal description. And again, the best place for this often is the previous deed, especially if that deed was a warranty deed, as the legal description has been warranted to be absolutely correct. You don't want to look at your tax statements and attempt to derive the legal description from your tax statements, because it's not always accurate. There's difference between Torrens property and abstract property. There's a lot that goes into it, but it is not just your address, it's not just your parcel ID. The legal description is something else, and it's extremely important that you get it correct. I have helped people to correct a wrong legal description, and I can tell you court is involved, attorney's expenses are involved. It becomes meddlesome, time-consuming, and expensive to get it figured out after the fact if you get something wrong in that legal description. You also want to make sure that the names of your grantees are exactly correct, because those are the people who are going to be receiving, and you don't want them to have to prove that they were the ones that you were intending to leave the property to when you got the name of a grantee just a little bit off. Finally, you want to make sure that it is signed by all grantors who are going to be signing it and their spouses in front of a notary. Again, spouses have an interest in the real property that their spouse holds, so it's really important that if you want it to be effective, it has to be signed by the grantors and by the spouse in order to transfer property in the right way. And finally, number 4, you have to make sure that the transfer on death deed is recorded correctly. And there's a little different way that this works. If the property is abstract, it goes to the county recorder. If it's Torrens, it goes to the registrar of titles. They have a different way of keeping information, and they have a different level of scrutiny that they apply to the transfer documents that come in. But it's very important that you submit it to the correct office at your county. Transfer on death deed has to at least be filed before the death of the grantor, preferably recorded at the grantor's death in order to be effective. And I can tell you, I have had people come to me for probate consultations in the past, and they have brought a transfer on death deed that they're very proud they got mom's signature on, but unfortunately it didn't have the notarization on it, or it never was recorded. They just kept it in the file and didn't actually send it into the county. And when that happens, unfortunately, a probate is needed because the transfer on death deed wasn't correctly recorded and therefore wasn't able to take effect when that grantor passed away. So that's a little bit of information about transfer on death deeds. They're a fantastic tool as part of an estate plan in transferring real estate. There are some really good uses and some really good opportunities to make use of them, but I want you to keep those 4 cautions in mind. And really, it's best to ask an estate planning attorney or a real estate attorney to make sure that you're doing it the correct way and to make sure that it's going to have the effect that you want it to have. Again, my name is TJ Scott. I'm an estate planning attorney with the Law Office of Timothy J. Scott, and I can be found online at tjslawoffice.com.